Well, we all know that H-1B workers who lose their job generally receive a 60-day grace period, giving them time to find a new employer, file a change of status, or prepare to depart the United States. But last week, DHS had told us that they're planning on proposing a new regulation to eliminate the 60-day grace period. As of August 6th, that proposed rule was submitted to the Office of Management Budget for their regulatory review. It hasn't been published yet, so the existing grace period remains in place for now, but that gives you an idea of where DHS is headed when it comes to legal immigration. We'll also talk about USCIS's new policy where they can deny a application or petition without sending an RFE or a notice of intent to deny first. What should people do? Should they file a backup application in case their primary application gets denied? How should people plan for that change? We'll also talk about issues related to arrests and EAD cards. For example, someone who maybe was arrested for a reckless driving case, they were speeding excessively or something like that. How does that impact an OPT or a STEM OPT? What is the process right now in those situations, and what might it be if a new regulation is finalized as is? And then we'll talk about a common question that we get when someone has an H-1B transfer typically and receives that new approval notice. The spouse is on H-4 with their EAD. At what point is that EAD still valid? Is it tied to the old company's H-1B? Do they need to file a renewal of the EAD? We'll answer all of those questions as well.
I believe this proposed rule, the 60-day grace period, it's been there the 60-day grace period has been there where people, when they are moving from H1 to H4 status, when they're moving from H1 to F1 status, B2 status, H1 to different company though, and they need some time for them to move from one company to another company. And this was thought about and was being given for 60-day grace period. Now Trump administration want to close it. Of course, we know that what their intention is. All our audiences know that what the Trump administration wants to do it. The question is that when will this be effective, and is there any way to stop this one?
So, it is again just a proposal and it hasn't even been proposed yet. All that's happened is it's gone to the White House for their kind of pre-publishing review. So we don't know what's in it. All we can do is guess based on the title, which is specifically eliminating the discretionary 60-day grace period. Doesn't sound good. It will be published and then give us a chance to submit our comments before they can actually finalize it. Given the current administration and how they've proceeded with some of these other regulations, our comments may not be taken into consideration, and they might go forward with it regardless. And I'm not sure how much we'll be able to fight that if they do finalize it, because they are actually going through the regulatory process this time around. In the previous administration, I think they did a lot of things through interim final regulations, emergencies, executive orders, and they got shot down a lot of times because of that. Now they're actually going through the regulatory process, but it's kind of a sham. They're just doing the steps without actually looking at stakeholders and seeing how it impacts them. So it's definitely not a good sign. Again, we have time. This is not something that's happening in the very near future, but it's coming as what their plan is going to be.
Emily, could they issue interim final regulations like the way they just issued interim final regulations with regards to online filing and some of the forms?
They always can, but they have to do so for a specific purpose. Like it has to qualify for that, either because of some sort of emergency situation or because it's just a procedural change that doesn't really impact anything from a substance standpoint. I don't think this would qualify for either of that. And again, there's just very little information. It was never even on the unified agenda, which usually all government agencies have to put out in the spring and the fall. what their plans are from a regulation standpoint. This one, we never got a spring agenda, and it was not on the fall agenda from last year. It just popped up as being given to OMB without any warning. So I don't know if I don't see them doing this as an interim final. I suppose they could always do that later. We'll see.
We also want to point out that for the students who are entering into United States on or after September 15th of 2026, and students who have going to travel outside the country and come back after September 15th of 2026, there used to be 60-day grace period. That has been cut down to 15 days. Sorry, that has been cut down to 30 days. So starting from September 15th onwards, if anybody is entering into United States on a student visa, or anybody who's applying for a change of status and approves after September 15th of 2026, they would get only 30-day grace period. They would not get a 60-day grace period as per the new regulations, which are already published. Just want to remind you about it. Emily,
So yeah.
Sorry, go ahead, Emily.
I was just going to say, so we have this new policy from USCIS saying that if you file something, maybe you file your H-1B extension, and we see that we don't think you qualify, we can just deny it. We're not going to send an RFE giving you a chance to respond. Should people be filing something else as a backup plan in that situation, or what should they be doing? And do you expect this to really impact business immigration based on what we saw during the previous Trump administration?
Definitely from the beginning, Emily, even when the Biden administration was there, even when Obama administration was there, we are always advising people to get the results of the visa status before their I-94 expires. Now, if they follow the direction, though, having a premium processing, especially on the H-1B visas, though, they shouldn't be into any trouble, because even if they deny it, let's say, for example, my I-94 is expiring in October of 2026. I file a premium processing. I get the denial in August of 2026. I get another chance to file an H-1B again. Or I can move to H-4, or I can try to do other visa statuses I can possibly do. So the options are always there. As we recommended, even Obama administration, every time we did the same thing. Nothing different, though, at this point of time. Now, I don't know at this point of time we should panic. There will be 1 to 2% of the cases I am suspecting that we may get the denials without an RFE, but a majority of them, they will still issue an RFE is what I'm feeling. Because last administration, Trump administration, they said that they are going to do it, but they haven't done that much on it. Now, we have to see as the things will develop. All these things, what we are speaking, are constantly, changing based on how the administration is ruling. We are not YouTubers. We are immigration practitioners. I've been practicing immigration law for like, I don't know, maybe 30 years. It's 31 years. I'm too old. I don't want to disclose Emily's experience. She's also very close by. So anyway, coming to the point, we have an office, and we have other lawyers. We have a law firm, and we discuss every Tuesday, every Friday. We have a lawyers meeting. We discuss about what's going on with the other things. We are also members of American Immigration Lawyers. We discuss all those things, and we present these things based on those things. And this is a constantly changing immigration, guys. So it is important that we put a lot of effort to bring this to you to a live session. And we really want you to come here if you're a non-immigrant visa, even right now on the green card. So these things of the F1, H1 changes, so these things are constantly going on. The RFP, will they do it? If they do it, we are going to inform you about it. So please subscribe to our channel, listen to our channel every Tuesday.
Yeah, and I'll just add to that, this time around, when they created this policy of we can deny without an RFE, they're trying to avoid frivolous filings and giving them some sort of interim benefit while the application is pending, or people who would file something as a placeholder while they work on getting more evidence. I think most employment-based petitions and applications don't fall into that category. So as long as you submit the required initial evidence that's specified for the particular form that you're filing, and that is on the USCIS website under every single form, we shouldn't expect to see these straight denials without an RFE. And again, if you are filing early, filing in premium to get the decision before your I-94 expires, you have backup plans already. However, if you are in a situation, there are some cases right now where even though you filed in premium, they're going beyond the premium timeframe. And if that is your situation and your I-94 is getting ready to expire while you're waiting for that decision, that's the situation where you may want to consider filing something as a backup, whether it's a transfer, whether it's a change of status. Um, you need to file something before the I-94 expires. If you wait until after the I-94 expires and then you get a denial without RFE, there's really very few options from within the US. You're almost guaranteed to have to leave the country and try to do something from abroad.
Emily, with regards to RFEs, are you seeing any RFEs if somebody has been arrested for speeding and especially for reckless driving? I'm not speaking of DUI, but also I'm speaking of DUI or other arrests that may be, but also for speeding. Have you seen any RFEs recently on OPT and STEM extension? If so, how to defend it? What is the best way to address those things, Emily?